swipe your credit card, put in a blank 9-track tape, and this is how long ago this patent was, and it would write that music selection onto the tape, and you could go away with it. The patent was drafted in a very, this very vague language, so there were terms like point of sale location and information manufacturing machine, and Freeney eventually sold this patent to somebody who wanted to interpret those terms very broadly to basically cover e-commerce. So here was this, this very limited invention for this kiosk, and he wanted to interpret those terms in such a broad way that it would cover transactions that took place over the internet, that you could make them in your office, in your bedroom, in your house, anywhere, and so it covered virtually all of e-commerce. The courts initially didn't agree with that interpretation, but they appealed it, and the appellate court largely agreed with them, and they were able to extract some settlements out of well over 100 companies. But the significant thing is, here is this patent. You can't tell what its boundaries were until you get to the appellate court. What most people thought its boundaries were turned out to be wrong.
One of the key properties of a programming language is very, very precise. You can look at any programming language in any language, any C, Python, or any language like this, and you know exactly what it's doing. And you can look at 2 pieces of source code, and you can say, are this doing the same thing or different things? And we do this because computers are very picky, and we need to tell the computer exactly what we need to do in order to accomplish some task. The language the patent lawyers use is almost the opposite. There's an advantage in being vague and in being broad and being non-specific, because the broader your language, the more things you sort of catch in your net.
So it is a large problem in our patent system, just defining simply what is the context or the borders of the patent. And what does it cover, what does it not cover? And that ambiguity causes a lot of chilling effect, because people are going to avoid doing anything that could possibly be covered by the patent, even if in reality the patent wouldn't cover what they want to do.
Let's imagine that in the 1700s, the governments of Europe had decided to promote the progress of symphonic music, or as they thought, promote it, with a system of musical idea patents, meaning that anybody who could describe a new musical idea in words could get a patent which would be a monopoly on that idea, and then he could sue anybody else that implemented that idea in a piece of music. So a rhythmic pattern could be patented, or a sequence of chords, or a set of instruments to use together, or any idea you could describe in words. Now imagine it's 1800 and you're Beethoven and you want to write a symphony. You're going to find it's harder to write a symphony that you won't get sued for than write a symphony that sounds good. Because to write a symphony and not get sued, you're going to have to thread your way around thousands of musical idea patents. And if you complained about this, saying that this was getting in the way of your creativity, the patent holders would say, oh, Beethoven, you're just jealous because we had these ideas before you. Why should you steal our ideas?
People have been making music for thousands of years. There was never any need for patents in the field of music. And since the computer industry has made programming possible, people have been developing software as well since the beginning. There was never a need to have patents in this field in order for the activity to happen.
Most everything we were doing back before 1980, before 1981, those things, patents played no role in it. Cut and paste, the embedded ruler in word processing, word wrapping, a lot of the things that are real important that we take for granted and that are much more innovative in many ways than many patents that we have today, because patents can be on some very, very minute things, and that's the way the law works. Those things happened. We had great advances without patents.
One of the world's most respected computer scientists, Donald Knuth, has said that if software patents had been available in the 1960s and 70s when he was doing his work, that it's probably the case that computer science wouldn't be where it is today. There would be blockades on innovation that could seriously have prevented the kinds of technical solutions that we take for granted today.
The programmer writing a long program might conceivably need to check whether 500 or 1,000 different techniques are patented, and there's no way that she possibly could.
The patent office issues hundreds of software patents all the time. Every Tuesday they issue 3,500 patents, and a large number of those relate to software. It's just impossible to review all those patents every week to make sure you're not doing something that could infringe them.
So there's a provision in the U.S. patent laws that basically holds patent infringers I guess, imposes greater liability if they're shown to willfully infringe. So basically the idea is that if you knew about a patent and you infringed on it, you should have a stricter penalty than if you didn't know about it. But what this results in is the situation where there's a real disincentive to follow what patents have been made and what new inventions there have been through the patent system. Because if you read every patent, then, or there's evidence to show that you've read patents, then you are liable for willful infringement. Then you knew about the patent and you infringed it anyway, and the penalty is treble damages.
A number of the people who filed briefs in this course suggested that software should be removed from the scope of patentability. Can you comment on that?
Yes, well, I obviously disagree with that, and I don't believe that software should ever be removed. It's one of our greatest sources of technical innovation in this country, and to come up with a test that would somehow eliminate software would, I think, be a disaster for the economy.
You know, Mike and I estimate that outside of pharmaceuticals and chemicals, the patents sort of are acting like a 10 or 20% tax. You know, so you can think of that, you know, the small developer who's developing something, down the road he's going to have to pay that tax. And you know, every small company I know in software, a few, you know, as long as they've been around a few years and hit the market, somebody is asserting a patent against them. They're running into some potential difficulties. They very frequently feel obligated to get patents themselves for defensive purposes. So all of that activity is a tax. It's something that's not helping them innovate. It's you know, an unnecessary activity.
The primary thing we do is an issue tracking system called RT, or Request Tracker. So it's customer service, help desk, bug tracking, network operations, anything where you've got a whole bunch of tasks that need to get kept track of, and you need to know what happened, what didn't happen, who did it, who didn't do it, when. It's kind of like a to-do list on steroids designed for a whole organization. Pretty much everything is open source or free software under one license or another. We will get consulting customers or support customers who add indemnification language to our standard contract or need us to sign theirs, and it says that in the standard legalese it's going to say something like we indemnify and hold them harmless and agree to pay their legal fees and sacrifice our firstborn if something happens and someone discovers that our software is violating a patent, is violating somebody else's patent. It's very, very rarely the case that we end up signing something that has that kind of language in it, but it eats up a lot of legal fees.
Look at the innovative people in software, in ICT, and ask, would they be better off if the patent system was abolished? The answer is probably yes.
Who's benefiting? Patent lawyers, number one. Number two, you have a small number of so-called trolls who are benefiting, but it's not clear that even most of them are making much money. You're seeing more recently, in the last 4 or 5 years, companies like intellectual ventures and hedge funds who are acquiring large volumes of these trash patents and using them to extract hundreds of millions of dollars from companies. They're benefiting. They may be the biggest beneficiaries.
You know, there's a lot of bad press in the last few years about the harm that's caused by software patents, and we think that's had a political influence on the PTO to get them to slow down their issuance and start rejecting them. And that's what's resulted in the Bilski case. Well, the biggest first bad press story was the BlackBerry patents, where all the congressional representatives have their BlackBerries, and there was a company called NTP that sued the manufacturer of BlackBerry, saying that all BlackBerries infringed its patent. Well, NTP was this company which is just a one-person holding company. They didn't make any products or services themselves. And so, you know, this got a lot of attention. It was in the Wall Street Journal and the Washington Post, and congresspersons were really upset that they may lose their BlackBerries and they may not be able to communicate efficiently. And so that caused a lot of attention. Then you had all these patents on like banking methods and imaging for checks that those patent holders have been asserting against the banking industry, and the banking industry has a lot of influence on Capitol Hill, and so they've been going down there and saying, look, these types of patents are causing us lots of harm. Then you add into that the whole patent troll phenomenon in the Eastern District of Texas, with small patent holders suing large IT companies like Google and Microsoft and IBM and Hewlett-Packard, and all these companies also have legislative influence, and they've said, you know, these types of patents are causing real harm to our business, they're costing us jobs, they're increasing the price of products and services that we offer to our customers, and you need to do something about it.
The situation we find ourselves in is that the lower court, the Court of Appeals for the Federal Circuit, is essentially a court for patents, for hearing patent cases. And this is the first time that the Supreme Court has taken up that scope of patentability. And specifically, this test that was implemented by the lower court does talk to software patents. And so there's basically a 20-year history of software patents being granted due to the lower court. And so we are hoping that the Supreme Court will clear up the mess that the lower court's created and restamp its authority, which basically said that you cannot have software patents.
When you saw the arguments that were brought by Bilski's lawyer, the patent bar is, in some sense, an organized lobby, and a expansive subject matter that's available to be patented is in their interests. And it's clear that that was frustrating to some of the justices. Some of them were frustrated by how expansive patentable subject matter has become.
I mean, they seem somewhat dismissive of the idea that you could patent this particular idea.
I think that people have a hard time getting over the idea that you could get a patent on hedging commodity risk. But if you actually look at the claims and look what's in there, it is a process, and it's no different than any other process. It just may be that it's not the way that they thought of patent law in the past.
We were encouraged by the comments by the justices which showed that they were skeptical and which suggested that they understood that software is little more than a series of steps that could be written out as a mathematical formula or written out on a piece of paper or, as was mentioned by one of the justices, typed out on a typewriter.
Software patents on a general purpose computer have never been explicitly endorsed by this court. And this court has also shown no compunction about reversing rules that have held for a very long time. They clearly thought that the petitioners here were trying to get a patent on something very basic, some basic forms of human activity.